The central error that the Court of Appeals committed in this case was reversing in part and remanding the case for consideration of the scientific reliability of polygraph evidence when no party in the case has contended or is arguing today that polygraph evidence is indeed scientifically reliable. The entire purpose of the polygraph being brought to the attention of the trial court was to argue all the circumstances surrounding one of the 5 or 6 individual statements given by my client in this case, as Jackson v. Denno would have us do. The constitutional conundrum faced by the trial court was that many of our evidentiary cases in South Carolina have suggested a general rule of inadmissibility pertaining to polygraph evidence in the absence of any type of scientific reliability associated with that evidence. At the same time, the trial court was faced with, again, Jackson v. Denno's mandate that all the circumstances pertaining to any type of statement given by a defendant in a case be presented to a jury for the jury to determine on its own volition whether or not that statement was coerced or in any other way forced out of the declarant. So the trial court was faced with something of a Hobson's choice. Either admit some...
What was the Hobson's choice? I mean, you got, and this isn't a hostile question, I'm still very curious as to why the state proceeded as they did. You got a host of statements by your client.
Yes, Your Honor.
There is one statement that is at issue here, as I understand.
That's correct.
It's statement number 1. And why would the polygraph be impactful in considering that statement? You all made a very clever argument below, trying to kind of force the issue that, hey, if you let it in, we've got to have the polygraph. I don't know that you really wanted that or not, but why would the polygraph be any necessary component of a decision about the admissibility of statement 1?
Well, it doesn't go to the admissibility. The trial court has ruled that it's admissible. What it would go to is the voluntariness of the statement that the jury has to consider under Jackson versus Denno. And the voluntariness is, the jury is required, the court is required to provide the jury with the totality of the circumstances pertaining to that statement 1, which we are arguing about today. And the major circumstance, I would argue, pertaining to that statement.
Polygraphs are not precluded as an investigatory tool.
Correct.
So now, is there some prohibition about informing the person under investigation of the results of the polygraph?
No, there's not there's no prohibition against informing that person at all, and there's no, in fact, no prohibition against lying to someone that's being investigated.
Absolutely. So I guess it harkens back to the Chief Justice's question: what's the problem here?
Well,
why are we really here?
The reason why we're here today, I would contend, is to take advantage of an opportunity to clarify South Carolina law, to say that there is no problem with a polygraph being introduced for the limited purpose of explaining to the jury the totality of the circumstances surrounding a statement.
Well, as I understand it, what you all wanted to do, statement 1 is there. There's a question about whether it comes in.
Correct.
And you wanted to be able to say she was coerced into giving statement number 1 because he asked her to take the polygraph and told her she lied, and then she gave the statement. Is that what we're talking about?
That's correct. We want to argue the coercive effect of the polygraph on statement number 1.
So it really doesn't matter what the polygraph result was. The fact that they wanted her to take a polygraph and then tried to badger her about whether she lied on the polygraph, that is what you want to discuss with the jury. Have come in.
I would modify your statement slightly by saying that the result, being told that you failed a polygraph, is important as far as the coercive effect of that is concerned, but the reliability of that result is not important because, yes, sir.
And they appealed it to the Court of Appeals, stating that the judge, because a polygraph might get mentioned, that there was an absolute prohibition to the introduction of a polygraph in this state, which is not correct, is it?
It's not correct.
But you're notwithstanding the fact that it might not have been important enough for them to appeal, but it's not correct. And all the Court of Appeals did, as I understand it, is remand it to the judge to determine, to make specific findings, perhaps a 403 analysis, that kind of thing, as to why this statement should or should not be suppressed. Isn't that essentially what they did?
Well, they asked the trial court to conduct a new counsel analysis of the scientific reliability
Okay.
of that polygraph, which, again, we would continue is irrelevant in this case because neither the defense nor the state is advancing the polygraph evidence as scientifically reliable evidence, something that would be in need of a Rule 703 analysis under the Counsel Jones standard. So what we are here today to do is to say either, yes, this is correct, we are not going to allow a statement that's been procured via polygraph or via threat of the use of the polygraph to be presented to a jury, or we're going to figure out a way to allow those statements in and without either A, violating the Jackson versus Deno totality of the circumstances standard, or B, prejudicing the jury by letting this polygraph evidence in, because that's what this court and other courts across the country have expressed their concern about with regard to polygraph evidence over the last several decades. And really, I believe that the state agrees that it's possible to do that, and we agree it is too. And the two options that I've been able to find in the various states' case law across the nation can be expressed in the New York, Maryland rule, and then in the Oregon rule. The New York, Maryland rule being that if we allow this evidence in, the jury is instructed that the evidence is not to be considered with regard to truth or falsity, but only as to the coercive effect that the polygraph might have had on the person giving the statement.
So the ruling you want us to make is polygraph evidence is not per se inadmissible, A. B, you can't put a statement in that was obtained after a polygraph and obtained by projecting to the defendant that they had flunked the polygraph. You can't put that statement in unless you also put in the facts of the polygraph.
Correct. Yes, Your Honor.
What you asked for.
And that's a bit of a tough decision for a defendant in a case like this. Do you really want evidence of a deception-indicated polygraph result coming into the jury? And sometimes you do, and sometimes you don't. In this case, if the statement's going in front of the jury, we want that evidence in there. And now the Oregon rule is the one that we advocate in our brief, because the Oregon rule thrusts that decision upon the defendant, that the state can advance the statement itself to the jury, and the defendant then in cross-examination can bring up the point that that statement was procured via the use of a polygraph or the use of those polygraph results. And that way, the defendant is not always under the threat of those types of results coming in.
So the polygraph would be in the control of defendant and not in the control of the state.
Correct. And so it would be the defendant that would be making that decision that Your Honor just pointed out can be a thorny one, that, do you really want to get what you asked for in that situation? In this case, we would like to get what we had asked for, and would like to argue to the jury that the statement 1 was coercively procured via the use of the polygraph. If there are no further questions, that's all I have.
Thank you, Mr. Newman.
Thank you.
Mr. Blitch?